Hello everyone. So today I'm going to discuss about the Indian Contract Act 1872. Indian Contract Act came into force on 1st September 1872. The act is applicable to whole India except the state of Jammu and Kashmir. It contains 266 sections. What is a contract? The term contract is defined under Section 2H of the Indian Contract Act 1872 as an agreement enforceable by law. The contract consists of two essential elements, an agreement and its enforceability by law. Agreement. The term agreement given in Section 2E of the Act is defined as every promise and every set of promises forming the consideration for each other. Here are some of the essentials of a valid contract as stated in Section 10. Two parties. One cannot contract with himself. A contract involves at least two parties, one party making the offer and the other party accepting it. A contract may be made by a natural person or by other persons having legal existence, example companies, universities, etc. Offer and acceptance. An agreement is the first essential element of a valid contract. According to Section 2E of the Indian Contract Act 1872, every promise and every set of promises forming consideration for each other is an agreement. And according to Section 2B, a proposal, when accepted, becomes a promise. An agreement is an outcome of offer and acceptance. Must create legal relation. There must be an intention on part of the parties to create legal relationship between them. Social or domestic type of agreements are not enforceable in the court of law and hence they do not result into contracts. Agreement should be certain. The agreement must be certain and not vague or indefinite. Free consent. Two or more persons are said to consent if they agree upon the same thing in the same sense. A consent would be considered as a free consent if it is not caused by coercion, undue influence, fraud, or misrepresentation or mistake. Consideration. It is referred to as quid pro quo, that is, something in return. A valuable consideration in the sense of law may consist either in some right, interest, profit, a benefit accruing to one party, or some forbearance, detriment, loss or responsibility given, suffered, or undertaken by another. Agreement must have legal object. The consideration and object of the agreement must be lawful. Section 23 states that consideration or object is not lawful if it is prohibited by law, or it is such as would defeat the provisions of law if it is fraudulent or involves injury to the person or property of another or court regards it as immoral or opposed to public policy. Writing and registration. A contract must be in written or oral form. In case of certain contract, the contract must be in writing. Example, contract of insurance is not valid except as a written contract. Classifications of offer. Express offer, implied offer, specific offer, general offer, counter offer, continuous offer, cross offer. Express offer. An offer made by express words, spoken or written, is known as express offer. Implied offer. An offer that is to be inferred or understood from the conduct of the parties or circumstance of each particular case is known as implied offer. Specific offer. An offer made to a specific person or a group. General offer. An offer is made to the world at large. It is known as general offer. Cross offer. When two parties exchange identical offer in ignorance at the time of each other's offer, the offers are called cross offers. Counter offer. When the offeree offers to qualified acceptance of the offer subject to modifications and variation in the terms of original offer is said to be counter offer. Standing offer. An offer which is allowed to remain open for acceptance over a period of time is known as standing or continuing or open offer. Tenders that are invited for supply of goods is a kind of offer. Who can accept? In case of specific offer, an offer is made to a specific person. Only that specified person can accept it. In case of general offer, any person from the public can accept it. Essential elements of valid acceptance. Only the person accept the offer to whom proposal is made. Only accept when acceptor have knowledge of offer given. Absolute and unconditional. On time. Communicated in prescribed manner. Express or implied. No cross offer. Offer once rejected cannot be accepted. Lapse of acceptance. Expiration or lapse of offer is due to rejection by offeree, counter offer, conditional acceptance, valid revocation by offeree, death of offeree, cross offer, illegal offer. Types of acceptance. Express acceptance. An express acceptance occurs when a person clearly and explicitly agrees to an offer. Implied acceptance. Implied acceptance is that in which acceptor not tell or write the acceptance but express through the act of him or her. Consideration is defined under section 2D. When at the desire of the promiser, the promisee, or any other person has done or abstained from doing or does or abstains from doing or promises to do or abstain from doing something, such act or abstinence or promise is called consideration for the promise. Consideration. It is quid pro quo, something in return. It is the price of promise. Here are some of the rules of consideration. It must move at the desire of the promiser. It must move from promisee or any other person. It can be executed or executory. Consideration may be past, present, or future. Consideration need not be adequate. Here's a case law of Chinnaya versus Ramaya. A old lady left her entire property to his daughter Ramaya, under the condition that she will pay a certain amount of money annually to Chinnaya, her uncle. Ramaya promised to pay the agreed amount annually, but stopped doing it after a time on the plea that no consideration moved from Chinnaya to herself. But the plea was rejected by the court. It was held that an indirect consideration had moved from her uncle. Types of consideration. Consideration can be past, present, and future. Case law of Durga Prasad versus Baldeo. In this case, a party, B, spends some money on the construction of a market. At the desire of the collector of the district, D promised to pay commission to B on articles sold by him in the market, in which he occupied a shop. In a suit by B, it was held that there was no consideration for the promise made by D, hence no contract, as he had not constructed the market at the instance of D. Legality of object. A contract must not only be depend on mutual understanding of competent parties, but also have a lawful object. Capacity of contract according to section 11. Every person is competent to a contract who is of the age of majority according to the law to which he is subject and who is of sound mind and is not disqualified from contracting by any law to which he is subject. Who is competent? A major, sound-minded person. Contract not be disqualified by any other law. Who is not competent? A minor, that is a person who is under 18 years of age. Unsound person. Quasi-contract. Quasi-contract is a contract which is not actually created by law. It doesn't arise by virtue of any agreement, but the law infers or recognizes these contracts under special circumstances. No intention of parties to enter into a contract. Thank you.